and welcome to the CYCJ webinar today. I'm delighted to introduce you to Tim Chapman, who's going to join us to discuss the relationship between children's rights and the practice of restorative justice. Tim is one of the UK's leading experts, if not the UK leading expert, in restorative justice approaches and processes. He's chair of the European Forum for Restorative Justice and regularly speaks at international conferences, and he's also a visiting professor at the University of Strathclyde. So very pleased to have him with us today. So without any further delay, I'm going to hand over to Tim. As always, there'll be a bit of opportunity to send questions in via the chat function, and anything else I'll send to Tim to see if he can answer them. Thank you very much.
Thank you very much, Charlotte, for the invitation. It's a great pleasure to be here. I think this is a good time to be speaking about children's rights and restorative justice, particularly in Scotland. And I'm very well aware that the Scottish Parliament incorporated the UN Convention on the Rights of the Child into Scottish law this March. And of course, the Scottish Government is also implementing a restorative justice action plan with the aim of having it widely available by 2023. On the face of it, children's rights and restorative justice are a good match. They're both interested in protecting children from harm, their best interests, non-discrimination, and especially, I guess, the strong point of restorative justice, it offers a very practical way for the voice of the child to be heard in important decisions over their lives and well-being. However, what I want to do is pinpoint a few tensions that have arisen in the research and offer a way of understanding how those tensions might be resolved. What I have to say is based on a chapter of a book that I hope will be published later this year, that I've edited with Annemieke Wolthuis, who's a children's rights expert in the Netherlands, and it's on restorative justice from a children's rights perspective. And it's a book of chapters about the relationship between restorative justice and children's rights. It attempts to have a global scope. It reviews international documents and describes legislation and practices throughout Europe, Africa, Asia, Latin America, North America, Israel, and New Zealand. And most of the chapters, I think, demonstrate the compatibility between rights and restorative justice and the importance of a rights approach, both in countries initiating restorative justice, in the early stages, but also countries that have developed restorative justice and are using a rights approach to, if you like, push against the current restrictions and try and develop the scope of restorative justice within and beyond the criminal justice system. My interest in this issue started when about 20 years ago Northern Ireland passed a law to introduce restorative justice for young people through our youth justice system. And the law was pretty, I think it was more radical than it realized it was, because it basically said that every young person who admits to an offence will be offered an opportunity to have a meeting with their victim. I think this was radical in that it wasn't up to the prosecutor or the judge or the social worker to decide whether it was suitable or not. They must be offered it. And only in very exceptional cases would it not go ahead. Obviously, it would be based on the consent of the young person and the consent of the victim. As you can imagine, there was some resistance to this from the legal professions, taking away their discretion and power. But actually what worried me most was the resistance from people that I'd seen as friends and colleagues and allies, and that was the children's rights lobby. They reacted very strongly to what they saw as a challenge to children's rights in restorative justice, and that has got me thinking. Nevertheless, I defended restorative justice as a way to increase the participation of children in justice issues. And it turned out that the scheme that was set up, that I had part in designing and training people in, was generally considered a success and effective, and it's been going now for nearly 20 years. Tens of thousands of conferences have been completed, and there's no big push to change the law. It's accepted. It's just become the normal way of doing things in relation to youth justice in Northern Ireland. And then my PhD student, did some research, and much to my disappointment and distress, discovered that the scheme that had been set up in Northern Ireland was not as good as I thought it was. And that got me thinking and reading a bit more about how restorative justice can also steal the rights of children. This is the title of my chapter in the book, Restorative Practices Can Steal the Rights of Children Too. This is a reference to Niels Christie's article, which related to the state and professionals stealing the conflict from the parties. I've used it to argue for a value-led and evidence-based approach to restorative justice, and I'll come back to that in my conclusions. So what I did, just a quick reference to my work in the European Forum for Restorative Justice. We've been working on defining restorative justice, defining its values, its principles and standards. And this is what we've come up with as a quick definition of restorative justice: connecting people to restore just relations. And I hope that you can see that there's a relevance to rights in that definition, in that it seems to me that human rights, children's rights, are at the core of what we might call just relations. Relations in which there isn't domination, exploitation, oppression. And that restorative justice tends to connect people so that they can restore the relationships between them after an injustice or a harm onto a more just foundation. This is a more detailed description of restorative justice. It's an inclusive approach, addressing harm or the risk of harm through engaging all those affected in coming to a common understanding, an agreement on how harm or wrongdoing can be repaired, relationships maintained, and justice achieved. Again, it seems to me very consistent with the UN Convention on the Rights of the Child. But when I started to look at three particular articles and examine the research into restorative justice, particularly the critical research or research into some of restorative justice failings, I discovered that there were problems. So if you look at Article 2, which is designed to protect children from discrimination, restorative justice does not come out that well, to be honest. In fact, there's very little research and very little theory on restorative justice, on race, gender, neurodiversity, LGBTQ+, and disability, amongst other areas of discrimination. It's had very little attention in the literature. And indeed, some literature has found that it has not been effective in countering economic and social disadvantage, for instance, of Indigenous young people in New Zealand and Australia. And this is particularly significant within the restorative justice field, in that we often point to our origins in the Indigenous communities of New Zealand, Australia, Canada. Particularly New Zealand, the Family Group Conference is meant to be based on Indigenous concepts and practices, but actually found empirically to be less effective in meeting the needs of young married people. And as many of you will know, that in both Australia and New Zealand, the Indigenous people are grossly overrepresented within custodial institutions. And in fact, Kuning has concluded that in relation to the politics of decolonisation, Changes brought about by restorative justice have best been superficial and at worst have reinforced existing power relationships. So definitely, this is not a strong point for restorative justice. Then I looked at the other sort of core article on the best interests of the child. And again, there's been a lot of criticisms of restorative justice in this area. Young people's participation in restorative justice has been criticised on the grounds of their immaturity and stage of cognitive development, which is said to disadvantage them in a process which demands verbal ability, empathy, and concentration. In other words, that restorative justice is really being designed for adults, not children, and doesn't take into consideration the best interests of the child. For some, the best interest of the child is in tension with the restorative value of responsibility and the process of making oneself accountable to the person whom one has harmed. And I think this was the argument that I heard most in Northern Ireland from my colleagues. That I think one of the ideas behind the sort of children's rights movement, certainly at that time in Northern Ireland, was that children are victims. So how can they have victims? That we need to protect children, even when they're seen to have offended against other people, even when they've offended against other children, for that matter. And so the notion of accountability sat very uneasily with children's rights activists. Wood in Australia refers to research that found that not only does restorative justice not address the symptoms of serious trauma, but it may aggravate them through the stress of disapproval and shame. And he maintains that a traumatized young person reacts to these sort of triggers and thus cannot be seen as a rational and accountable actor within a restorative process. So on two very basic counts, restorative justice struggles to match the demands of children's rights. And then looked at Article 12, which refers to respect for the views of the child. And this is an area I thought, right, this is where restorative justice is going to come out well, because restorative justice is all about inclusion, it's all about participation. It's about enabling people who have been affected by harm to tell their story, express their feelings, ask questions of each other, make requests of each other to restore the situation that they find themselves in. So I thought this is going to be somewhere where we're going to come out pretty good. In fact, the opposite was the case. My student at Ulster University, who did a thesis on this, observed that young people in Northern Ireland feeling vulnerable and ill-equipped to express their views in a room full of adults, which is a phrase from Haynes's work. Constantly they can be intimidated, orchestrated, or coerced into doing what's expected of them. Observing restorative conferences, it often seemed to Barnes that the process was scripted to lead to an apology and to agreeing to a predictable reparation plan. Now, I should say that these observations were on the basis of a minority of cases that she observed. It wasn't the general trend, but it was a large enough minority of cases to be deeply worrying that it should be happening at all. I was interested in some of the work of people working within the discipline of linguistics, and they applied their knowledge to restorative conference. And again, they found that the practitioner controls most of the communication. As they put it, the convener initiates virtually all exchanges and introduces virtually all explicit evaluation, to which the young person responds compliantly, a word or a phrase at a time. Very passive form of participation. Continuing to look at Article 12, Rosenblatt, during youth offender panels, this was in England, noticed that the community panel members do most of the talking, and the youth offending team worker dominates the decision-making through a report that recommends what the young person must do. This seems to defeat the purpose of a young person participating. Another some research in England observed a police officer scheme, and so that police officers often pursued their own preferred outcomes on many occasions rather than enabling the participants' wishes to emerge from the dialogue. Often victims were not even asked what they wanted to happen. And doubts have been expressed about adults exerting undue influence over the child's admission of responsibility for the harm. And Skeleton, writing in South Africa, stated that because most current restorative justice processes require the offender to acknowledge responsibility before referral to a restorative justice programme, the rights to be presumed innocent until proven guilty and to remain silent are no longer applicable. Some argue that the offender is voluntarily relinquishing these rights in order to benefit from the restorative justice option. But the extent to which these decisions are made voluntarily is in doubt. So this again casts doubt on the notion of free participation. Young people in restorative conferences have been observed as struggling to express themselves and to give full account of the harm that they've caused. As a consequence, their meaning may be misinterpreted, and often victims then distrust their sincerity, feel that they're not being sincere, they're just putting on an act, they're just trying to play the system. And this may be due to language and communication problems, which tend to be more prevalent amongst disadvantaged young people who offend. And partly because the process, often scripted and based on the notions of respectful conversation, empathy, taking responsibility, tends to privilege middle-class styles of communication, according to Wolthuis. Reparation is fairly basic to the notion of restorative justice, the notion of repairing the harm that's been caused. And yet it's been found, for instance, in the Thames Valley Police initiative, that material reparation was rarely agreed, and that most reparation took the form of an apology, irrespective of what the victim wanted. Victims were often unmoved by written apologies, particularly if they had not been there to tell their story. Many had been led to expect financial compensation, and so were disappointed. Where this was agreed, there were many cases where the commitment to compensation was not kept or followed up. Again, Rosenblatt found that referral orders, which is a restorative provision in the law in England and Wales, often consisted of activities more designed for rehabilitation than reparation to the victim. When reparation was agreed in a referral order, the young person was usually referred to a pre-existing reparation project already organised, rather than one designed to meet the victim's or community's needs arising from the harm. And in some cases, it was decided that a referral order could be discharged even though the young person had not completed the agreed reparation. In other words, that the rehabilitation aspects of the order were prioritised over reparation, thus undermining the restorative nature of the referral order. Given what I've said, it's hardly surprising that many schemes report a very low level of direct victim participation. Now, bearing in mind that often the victims are also children or young people, they are being excluded. You can see the statistics there, 13%, 9%, only 1 out of 39 panels that Rosenblatt observed had a victim participating, 14%. Very similar figures. And so this led to practitioners constructing surrogate victims or imaginatively describing the impact of the offence without any direct evidence. Such tactics take the process away from its restorative and reintegrative principles and tends towards shaming and stigmatising the young person. Now, research suggests, again from Northern Ireland, Barnes, that the Public Prosecution Service exerts a controlling role over the conference plan, regardless of stakeholder satisfaction. Facilitators were heard to say, I need enough in this plan to get it through the Public Prosecution Service. But at the end of the day, the Public Prosecution Service have to decide if they want to agree with the plan. So this was a sort of intrusion of somebody who was not present in a conference having a significant impact over the agreement, which, according to restorative processes, emerges from the dialogue between the perpetrator and the victims of the harm. So this is what I mean by stealing rights. Now, let me emphasize once again, this is in a minority of cases, but sufficiently reported in the research to see that it is significant, and that in many ways restorative justice is failing to live up to its own values, and certainly to comply with a strict compliance with children's rights. So why should this be? Well, firstly, restorative justice is what I would call a small fish in a big pond. In other words, it works within the criminal justice system and other large systems which are well-established, hierarchical and powerful systems. And it requires the systems reports to get funding and authority to practice within those systems. So very much subject to the influence of the context in which it's practiced. And so there is what I would call an institutional colonization of restorative justice. In other words, the more powerful institution imposes its values, its priorities, its strategies on the restorative process, and overrides many of the restorative values that have been shown to work. Examples of this is a lot of the research that I've just quoted are looking at restorative justice from a criminal justice point of view, from the point of view of things like risk management, reoffending rates, rehabilitation, the sort of tariff that prosecutors and judges have in their mind, depending on the seriousness of the offence. These values, which are not restorative values, invade the restorative space because the restorative justice process needs to work within the institutional constraints. Another pressure which explains some of the changes in Northern Ireland from what I thought was a well set up scheme to some of the criticisms that Barnes found in her research is the notion of McDonaldization. When restorative justice was set up in Northern Ireland, it was well resourced. The government wanted to succeed, it resourced it, and it did very well. But then we had to hit a recession, a period of austerity, there were cuts, and so the managerialism became more important to get through as many processes as you can, as cheaply as you can. So, you know, shortcuts were taken, victims were excluded, and so there was this sort of standardized production line of restorative justice rather than the care and attention that it should have taken from a restorative point of view. So that's that sort of influence of managerialism and McDonaldization can very quickly dilute the restorative nature of restorative justice. And also this infects a professional culture and privilege. Niels Christie's article was really a critique of the professionalization of criminal justice and how the resource of conflict was being taken away from ordinary people. And I think that's still around, that professionals are jealous of their status and of their privilege and of their power, and are not above using the concept of children's rights to enhance their decision making. For instance, who decides what's in the best interest of a child? Often professionals feel that they're the only ones qualified to do that. So the lived experience of ordinary people, which I believe is the basis of restorative justice, is subordinated to more powerful values, strategies, and priorities. And there's a focus on the person, fixing the person, correcting the person, punishing the person, rather than on the concept that I think restorative justice bases its practice on, is the focus on the harm and its ripple effect and how to repair that harm. There's increasingly, when people say, does restorative justice work? They're basically asking, does it reduce reoffending? And restorative justice was not necessarily designed to reduce reoffending. It was designed to restore what has been lost, damaged, or violated through an act of harm. And again, there's an emphasis on risk management, and does it meet the needs of the participants, rather than a focus on the obligations that we have to each other as citizens and members of a community. So there's a tension again there, different values, different priorities, different ways of looking at harm. And as I said before, sometimes, and certainly I've experienced this in Northern Ireland, the use of rights can actually be used to increase the decision-making power of institutions and professionals. And professionals are not above using the notion of rights to avoid doing work that they feel uncomfortable with or don't have enough time to do when they're under pressure. Bell Hooks, African-American cultural theorist, I think sums up what I'm trying to say very well. When she writes, "No need to hear your voice when I can talk about you better than you can speak about yourself. No need to hear your voice. Only tell me about your pain. I want to know your story, and then I will tell it back to you in a new way. Tell it back to you in such a way that it has become mine, my own. Rewriting you, I write myself in you. I'm still author, authority. I'm still the colonizer, the speaking subject, and you are now at the center of my talk." And this seems to me what can easily happen within restorative justice, just as it can happen in any profession, that the practitioner takes on the authority to know best and can use rights to support them, but is basically making their own lives easier and exerting their authority, their notion that they know best, they know better, and are more informed than the person that has got the problem or is suffering from harm. So in looking ahead at the development of restorative justice in Scotland, within a society that's moving towards a greater recognition of rights, it seems to me this research presents two problems. One is how to protect the restorative space within powerful systems. How do you maintain that space, which we know works when well facilitated, and can have many benefits for both those who have been harmed and those who've been responsible for the harm? And within that space, how to reconcile respect for individual rights with people's obligations towards others in the practice of restorative justice? Because I think ultimately, restorative justice is attempting through a process of dialogue to reconcile individual rights and obligations towards others. If you like, the reconcile the respect for individual dignity and the notion of solidarity and obligation and responsibility to others in society. Firstly, I would say that we need, if we're developing restorative justice in Scotland, to use the idea which I discovered in Piaget's work of accommodating rather than assimilating. The system will just without thinking want to assimilate restorative justice into its current way of thinking and practicing. Whereas if it really wants to experience and benefit from the value of restorative justice, it needs to accommodate that restorative justice. In other words, create space for restorative justice to do what it does best through its own values and principles in a way that is compatible with the system's needs, but not completely dominated by it. Goethe's writing on rights, I think, is helpful to me in this. He distinguishes between rights which protect people from oppression and those which support human flourishing. And if we can understand that distinction and organize the rights in a way that creates this space, then I think we can go towards reconciling children's rights and restorative justice. It's similar to what Braithwaite wrote about constraining standards which provide participants protection from domination by others. And again, I would go back to the core rights within the convention. The two core rights, the principle, the best interests of the child. I think these can create filters through which the children can enter the restorative space. In other words, they should only embark on a restorative justice program if it is clearly in their best interest. And I think in the vast majority of cases it will be if restorative justice is done in the right way. So they need to understand that they can make a free and informed choice whether to participate. And it follows that the process must be designed and facilitated so it's safe, avoids degrading or humiliating treatment, and addresses the needs and interests of the child arising from the harmful incident, whether they're the perpetrator or the victim. A restorative process cannot work unless the child accepts responsibility for committing the harmful act. It is critical that children who deny responsibility are not advised or persuaded to participate in a restorative process because it would be in their best interests. The principles of voluntary consent to participation and confidentiality are also important protections of the best interests of the child. Protection from discrimination, again, should be a filter, and it's a right that restorative justice must pay much more attention to. Restorative process should not only be inclusive, flexible, and adaptable to diversity, such as sexual orientation, race, ethnicity, neurodiversity, religion, class, disability, or domestic circumstances, but it should be actively designed to counter systemic discrimination, to engage in a way that is inclusive and culturally appropriate to people, particularly those who are disproportionately represented within the criminal justice system. It should be seen as a way of not just protecting people from discrimination, but to challenge it. And then within that space, the principle should be one of participation rather than domination by professionals or the system in which it works. And this is where Article 12 is very relevant, but also Articles 39 and 40, which emphasize the dignity of the child and recovery from harm and reintegration. These articles promote the flourishing of the child by animating, in my belief, a process of justice based upon inclusion, participation, accountability, truth-telling, and dialogue, but only if the conditions of best interest and non-discrimination have already been met. And this takes me to, I think, the importance of standards of quality, but not framed from the system's point of view, the institution's point of view, the practitioner's point of view, which most standards are. It's basically standards tend to be a list of things that are expected that the practitioner will perform. European Forum is looking at a way of framing standards from the point of view of how RJ should be experienced by its participants. So how would they experience high quality restorative justice, as opposed to how would the practitioner do it? So much more outcome focused and participant focused. And this is sort of different from just a list of tasks or standards that need to be ticked off by the practitioner. So in conclusion, Restorative justice has always, I suppose, claimed to work through the power of relationships. But I think, in my view, what children's rights introduces is a greater attention to relationships of power. I think restorative justice has sort of naively assumed that we were the good guys. We're facilitating people to make decisions, and not realizing that consciously and unconsciously practitioners have exercised power on behalf of institutions, systems, and on behalf of themselves. And we need to really guard against that and ensure that we maintain standards that are truly restorative. I always use this quotation in my training. It's from Miles Davis. This is what he said when Herbie Armstrong hit a wrong note during a concert. He said, when you hit a wrong note, it's the next note that you play that determines if it's good or bad. And this to me sums up the value of restorative justice. We live in a society which tends to judge both perpetrators and victims by the bad thing that they've done or has happened to them. Restorative justice enables both victims and perpetrators to judge themselves and to be judged by what they do next, the next note they play, how they respond to the harm through active participation in a process of justice. And finally, people, even more than things, have to be restored, renewed, revived, reclaimed, and redeemed. Never throw out anyone. When I teach this to my students, we play a game to sort of see if anybody can guess who said that. And people always think of philosophers and famous people, like Nelson Mandela or something. But in fact, it was Audrey Hepburn who worked for UNICEF towards the end of her life for children's rights. And it seems to me it sums up the integration of rights with restoration. Thank you very much for your attention.